All right, let's quickly take you back in time, right, to see where the legal battle over the seismic exploration along the Wild Coast began. And this is more than a decade ago. So a technical permit was granted in 2012, and this is when the saga begins. And you think about the following year, right, which then is a seismic exploration application, which we see in 2013. And then in around 2024, the exploration right is granted on the 29th of April. And this particular moment then begins what becomes a lot of conversation and uncertainty around what is to come. And around June 2021, Shell then takes a 50% stake in the right. But just months later, we see this matter then go into the court, I beg your pardon, and this is around the 28th of December in 2021, to block the survey in an interim interdict. And that's when the, really the legal battles begin to bubble under. So on the 1st of September, this is 2022, we then see the exploration rights that are then set aside, with the court finding that the communities had been excluded when it comes to meaningful consultation. And this is going to be the big subject of the next discussion that we are going to have, as to say, how then do you begin to see a change in what becomes meaningful consultation as far as this process, is concerned, or any other process that involves communities in the future. And then, of course, this particular process then looks at the communities are talking about how they are finding themselves, overlooked here, as far as, for example, when issues of the climate come into play, and then cultural issues. You heard Snekuku taking us through some of those as well. So also legal requirements not being met as well, as far as this is concerned. And then as we quickly then continue to take you to, the next stage of what becomes this particular fight. On the 3rd of June, we see the SCA upholding the unlawfulness of the exploration right, but critical to note, this is why we ended up in the Constitutional Court. It left the door open for a third renewal application, allowing Shell to try again. And this open door is where the communities were quite unhappy, especially when they're now taking the fight to the Constitutional Court. Then it prompted these 5 groups, part of which we spoke to here on the show: Sustaining the Wild Coast, Natural Justice, Greenpeace, All Rise, and affected communities, to now head to the Constitutional Court because they wanted certainty on this particular matter that would have been the final ruling. And then we then see on the 14th of August, the ConCourt rules, which is today. Quite a significant ruling, with the court ruling in favor of the communities. And you heard there the communities saying that they feel heard by this ruling of the court. And now the SCA order has been set aside, which effectively could mean the door has now been shut. So you look at the consultation. I did say this is very important. The consultation process is one that is quite in the spotlight, because when you listen to Justice Collapin, he talks about the importance of making sure that communities are not only consulted, but they're going to find themselves seated at the table in a meaningful manner. And now the finality of this particular ruling means the exploration rights have been set aside. And that has led the communities here to be happy about this decision. And it speaks about the significance of this ruling, which has changed a lot, especially when it comes to the lives of the communities along the Wild Coast. But what does it all mean, legally speaking, as far as, especially when you think about the issues of, exploration, the issues of public consultation is concerned? What then happens in the future? What precedents does this then, set as far as that process is concerned? So let's have this conversation and take this discussion forward. We speak to Adjunct Associate Professor of Environmental Law at the University of Cape Town and Head of Public Interest at Lawtons Africa, Dr. Melanie Murcott. Doc, good evening to you, and thank you so much for your time. Quite a significant ruling, hey?
Good evening, and thank you. Hugely significant. The judgment represents a major vindication of the environmental right. This is only the third time that the court has spoken meaningfully about the environmental right, and it's the first time the court has spoken about climate change and what international climate change obligations mean for the environmental right. So as an environmental law scholar and practitioner, it's a very significant legal development.
And it's quite significant because it also speaks about, for example, the right to a healthy environment as well as the right to the protection of the environment as well.
Absolutely. And so the judgment clarifies that the right to an environment not harmful to health or well-being imposes negative obligations on the state to prevent an environment that's harmful to health or well-being, for example, through extractive industries like what was proposed by Shell and Impact Africa. And then it says there are positive obligations also to protect the environment, and really crucially says that those obligations must be interpreted with reference to the International Court of Justice's ruling last year on states' obligations about climate change. And there are a few really important things the court mentions about that ruling from the International Court of Justice. I think the first is that there's a duty of our government not to cause harm within our borders to the environment that will then affect the whole climate system and the whole world, and the human rights obligations that it would breach by doing that. And then the second is that there's a due diligence obligation that our country owes, our government owes to the rest of the world to exercise what the ICJ, the International Court of Justice, described as stringent due diligence, and in the Constitutional Court it was heightened due diligence, before authorizing a development that could harm the climate system. So that's a really significant statement from the court.
And when you also look at another issue here, which was quite central, and I spoke to one of the applicants a little earlier on, is the issue of meaningful consultation. Because when one listens to the court, they take it a step further to say it isn't just about expressing an opinion. It is making sure that people are seated at the table and the communities can meaningfully participate. How does this then begin to change the process of what we are calling public consultation around some of these critical decisions?
Yeah, it's a great question. I think what the court was asked to do was decide what's a just and equitable remedy in this case. There was not really up for debate that Shell and the government had complied with the law. There were various problems. They hadn't consulted properly with the communities. They hadn't considered climate change impacts, and there were various other issues that needed to be dealt with. So the court was considering, under these circumstances, do I send this decision back to the minister for reconsideration? Is that a just and equitable remedy? Or do I just, as you said very well, make the issue final, that there can't be a further decision about this issue anymore? And the court said in this case, the consultation was so bad that communities weren't properly consulted in languages they understood. As you said, they weren't given a seat at the table. Monarchs were consulted instead of the community members, and directions about the need to include all community were specifically ignored, meant that a just and equitable remedy couldn't be to send this decision back. And the court even went so far as to say, to quote an African saying that translates into self-inflicted harm deserves no sympathy. And so that's how strongly the court felt about this issue. One of the key pronouncements on this for me is that in designing this remedy, saying no more going back for a further opportunity to consult and rectify the problem, a just and equitable remedy should not allow speculative or corporation-centered economic benefits to outweigh procedural justice, where communities' livelihoods, cultural identity, and environmental interests are directly at stake. And I think that is a very important lesson for corporations moving forward who want to seek authorizations, that they must do consultation at the outset and they must do it properly.
What does this case say, for example, around, South Africa's natural resources? Because I'm thinking about, for example, the Xolobeni community at some point that would have been fighting as far as the mining rights are concerned. And now here you are with another community that is saying respect our rights and respect, our oceans. And they speak about a myriad of other issues, livelihoods, the preservation of culture, etc. So what does it say about the broader struggle as far as natural resources are concerned in the country?
I think one of the critical things the judgment says is that communities must be included in these decisions, and where they are excluded and they also aren't going to benefit from these decisions but are going to face the most harm, that these decisions will be open to challenge. And so I think that this decision, by, first of all, requiring climate impact assessment as the international law requires, and by saying there must be meaningful consultation with those most affected, including with reference to their cultural and spiritual practices, has really strongly supported the environmental and climate justice concerns of communities.
It sounds like, quite the subject that still needs quite a lot of exploration, because I'm even thinking about economic development and community rights not sitting on the, different sides of the scale. But thank you so much, Doc. Appreciate your time. Unfortunately, time always the enemy, but thank you for speaking to us. And that is Adjunct Associate Professor of Environmental Law at the University of Cape Town and Head of Public Interest at Lawtons Africa, Dr. Melanie Murcott.